Telegram is not accessible.
Telegram
the other platforms are not accessible to me, and then they
size rest.
Because the material that I try to keep is a little enormous, so it will not be possible in any other platform. So I'll only ensure that Telegram will be somehow available to all of you.
Majority have joined.
And the issues are coming. Suniye, issues are coming only for few. Majority of them, as I can see, have already joined. So specific problems for specific people will address according to the problem that they have. We'll address them separately. Otherwise, when most of them are able to join, for others, unless there is a specific problem for them or with their network thing, I don't think it is, because many people have already shared, many people have already joined.
Ma'am, I don't think it's the network, because there's no network issues around here, and I tried to look up the channel.
I've
given link to channel.
We have already given the link, no?
Channel link.
Yeah, no, they're not opening. I tried.
It is opening.
You can try it out, because same thing when it is working for others, I don't know why it should not work for certain people. I am not that technically savvy, I don't know why it is not accessible to others. Because it will be difficult for me to, because I have to cater to the needs of so many people here, one diploma, the other PG students and all. It will be difficult in any other platform for me to share. Because the material that I try to post will be little enormous, big. That is the difficulty. Otherwise, I have no issue. We'll address that separately. What is the issue? We'll try to find out. I don't know why for some people it's not opening and all. We'll see that.
The issue is many of us are not on Instagram and Telegram.
Join karo na. Telegram join karne mein I don't think there will be difficulty.
What is your point?
There is no difficulty, but there is not many messages which you get which keeps disturbing you.
That's okay, but this is not a thing to worry you. This is only to as a means of facilitating the things, to a larger group. See, this is a platform created to cater to the needs of a larger group, isn't it? So I keep
Google Drive is the best for large group.
Personal, official, and what?
See, there are again 2-3 things here: official, personal. There are so many things, So Google Drive and all, I think it's not advisable. So we also try to have something, and they try to remove YouTube and all. I try to put, they have removed it. So I don't know what is the reasons and all behind these things,
Google YouTube restrictions.
There are a lot many restrictions in the other platforms.
I lost 1,000 videos.
MS Teams also works, because we've been using that for like past 3 years, even in our bachelor's.
We'll address the issue anyway. We'll try to address that issue.
Telegram
Should we start now?
Yes, ma'am, you can. And I'm also, like the previous materials that you will be also sharing the Telegram, right? That you have shared.
Telegram.
Telegram, I have already shared that. I have put in, because the other platforms, I try to keep many videos, and I have lost almost as many as 1,000 videos, which I am not able to retrieve now. So that is the reason I am afraid any other platform, if you use, there is other danger, because I don't know why YouTube and all I try to put, and they have removed that. It is some, not permitted and all, they have removed all that. So I don't want to again venture that and then take the risk of losing all the data. That is I have my own reservations for that, That is the reason Telegram group is a wider thing, and it doesn't pose any restrictions, and a number of material can be loaded in that.
Forensic material sensitive.
So what they say is this is little confidential, sensitive. Other common public and all may not like it, and then it is not in the public interest. Aisa karke some messages they gave, and ultimately they have removed the access for me for YouTube and all. So why that, when Telegram is offering me lot of scope without any restrictions. So my feeling is as well go for that, But anyway, it is not a matter for controversy or discussion. We'll address it. What we best we can do, we'll address it at a later point of time. But now that we have last 2 days, let us concentrate on what we have to address now. So I hope that whatever classes so far have been, yes.
Also, like, can you share the materials once again in the Telegram group? Because as for now, we can only access the materials that after we join the one.
We are putting up every day's material.
In the Telegram.
Every day's material we are putting up in the Telegram, isn't it? So it will be there. We have already every day's material we are keeping it.
We'll share again.
We'll share again. If you feel that you have not got the access, we'll share it again. We don't mind. After the class, let everybody join. We will do that. No issue. We'll do that. We'll do it. We'll again share it. No issue. Okay? Is that okay? We'll do that. No problem. Now, whatever we have covered in the previous classes, I think everybody is clear about that. And let us just, for recapitulation, we try to understand that there are a number of elements that compose a crime, and out of so many listed ones, we felt that only 2 things or 3 things rather are very important. One is about the act, and then the other one is about the guilty mind. The third one is causation. So like that we try to understand, and actus reus we have dealt in detail. What constitutes actus reus, whether there is any qualification for the act, or all acts are punishable, or all acts can be legally punishable. So which are morally, by doing which, whether you violate a moral or ethical law, or does it amount to criminal liability and all, we try to understand all that. And we also try to understand actus reus when it is specifically dealt in the statute, or if it is punishable as a penal law. Yes, what is the issue? Yes? Sharing is not the real picture. Yeah, you have to be very clear, there are a lot of issues here of internet connectivity. So what is the issue? Somebody is raising an issue. What is the issue? Let me know that. I think yes, is this visible now? Yes, is it visible and audible?
Yes, ma'am.
Yes, ma'am.
Yes, ma'am, it is.
But I am only trying to recap whatever we have done, and I am not moving the slides now. It is still on Mansiria slide only. But what I am interested is, the people should know this, because these are very, very important, and unless the basic concepts are clear, there is no point. Because the other acts and all, when we come to legal aspect, real aspect of understanding the CRPC, IPC and Evidence Act, will not be in a position to concentrate, or because once you have not understood, there is no point that you can concentrate and further understand. So I am again reiterating that basics are very, very important, and The crux of IPC is only in understanding these three concepts, the mens rea, actus reus, and then the cause. These are the only three things that are there. In different combination and permutation they will be appearing. So we have to be very, very clear about these concepts, and last class we have dealt about actus reus, and then whether direct participation can be construed as actus reus, or when there is an indirect participation, can that amount actus reus, or if there is an intervention, intervening acts, can that be caused? Because causation is another thing, we cannot just say direct act will result in. So in understanding proximate and remote, the more remote the cause, the more difficult it will be for somebody, for the investigating officer or for the prosecution to establish the mens rea. So that being the case, now they say proximity concept or the remoteness of the causation. Then there is it is a networking of causation. It is networking of causation. For example, take a case of a main surgeon, because in any major surgery, it is not the only surgeon who tries to participate and then complete the entire operation. If it is a very serious operation, it involves a team of doctors, isn't it? When you have to fix up the legal responsibility, or in otherwise criminal liability, then if suppose that results in the death of a person, the operation is successful, but ultimately the person dies, the patient dies. So if you have to understand that particular concept now, let us take this example and try to understand what is the proximate cause, and then what is the remote cause, and then how each one is linked to other one. So there are linked, that is called the networking of causation. Now take the example of a surgery, a major surgery being performed by the let us say the surgeon, main surgeon. Let us say a cardiac operation or a heart transplant, whatever is the main operation going on. Now open heart surgery, let us say. Now there is an anesthetist. So anesthetist also has to monitor completely the operation so that there is no fluctuation in giving the anesthesia. It should not be too low, at the same time it should not be too concentrated, and all depending upon the build of the person, the anesthesia has to be administered, isn't it? So there is one anesthetist, let us say, and after the main surgery gets over, the stitching part of it or some accessories part of it, it will not be normally done by the main surgeon, the top surgeon. So it will be given to some intern who is doing her internship or his internship. That will be given. Stitching is a very minor thing. So, and an intern is always, presumed to know these kind of small little things. So that is given to an intern in good faith. So what he does is he also feels that he has done it. And then there is, after that, even all these three people, they leave the operation room, and it is and they are shifted or in ICU, whatever. So a duty doctor will be allocated, and a group of patients will be under her control or his control, duty doctor's control. And afterwards, day to day, minute to minute monitoring will be done by the nurse. This is how a typical scenario of a very big operation that will be there. Now suppose let us say that the stitching part, that is intern, is a new fellow and he is not yet completed his let us say the house surgeonship, and he is in the process of completing that, and let us say the entire operation has started around 10 a.m. and by the time the anesthetist gets his work done, it is 10:05. And let us say around 10:30 the duty doctor, the intern stitches, and duty doctor attends on to the patient, let us say around 11 o'clock. And then of course there is a nurse who attends to the patient 12 o'clock, up to this time it's okay. But around 12:30, all of a sudden the person dies around 12:30. Now to decide who caused the death, then what is the proximate? The responsibility will fall on whom now? So what is the proximate cause? So how will you understand that? And who is the, if you want to put the cause or take as a remote cause, who will be the person on whom you can put the remote cause? Yes, I want interaction. So if you have to understand the proximate cause and the remote cause, because these are very important, not very in criminal, criminal law it may not be that important, but in torts and contract it has got its own significance. But then now to understand this, the proximate cause and the remote cause, I told you also the more the remote the cause, the more it will be difficult for us to fix the mens rea, whatever. So now as far as the surgeon is concerned, what will be can you put him under the clause of remote cause, or are you going to put him fix the liability as a remote cause? Yes?
Proximate.
Is it proximate or remote? How will you say?
Well, I will say it would be remote.
Whose main surgeons will be remote? That's what you mean to say.
Yes, yes.
And about when it comes to proximity of the causes, then on whom are you going to put the criminal liability?
The last officer who I have attended.
Last officer is only a nurse, a duty doctor and nurse. They are doing their routine. They have nothing much in the operation per se, isn't it? Before them there is one intern who has stitched, and the observation in the postmortem or whatever is that there is a lot of internal bleeding. If I give another clue, in the postmortem the doctor opined that there is a lot of internal bleeding, and instead of the heart pumping, the blood pressure has fallen down, and whatever stitches, because it's an open heart surgery, the stitches were I mean, how will the leak happen, or how will the bleeding happen and get deposited in the internal organs? Only when the stitch that is made is not proper stitch, improper stitch, or the intern has not taken enough caution to ensure that the stitch has been put in a proper way. Only then leakage can happen, isn't it? So if you want to put, as far as the criminal liability, if you want to put, who will be coming under the proximity cause and who will be coming under remote cause?
The intern would be the and the nurses will be under proximity cause and the doctor will be under remote.
What is it? Yes.
That interns will be coming under the proximity cause and doctor
Correct.
will be under remote.
Correct. Because the proximity cause is, I mean, the one who is the immediate one, because the all other, and that should be supported by the other circumstantial evidence. In this case, what example I have given, the doctor who conducted the postmortem after the death, because after all we need to know what is the cause of death, isn't it? When the operation is successful, when the main surgeon has performed it so well, he is such a renowned doctor and all, and when anesthetist is also a well-known doctor. Now it is only the intern, and that should be supported. You cannot just say fix the responsibility solely. There are so many factors involved. So that is the reason we say cause. When you want to know the cause, it is not based on one factor. We have to talk about the concept of plurality of the factors. When there are so many factors involved, to fix the exact criminal liability or culpability, then what you need to know is other circumstances or circumstantial evidence that is prevailing around the case, you need to examine. So in this case, as I said, in the postmortem, what are the outcomes? What are the outcome of the postmortem? Postmortem doctor very clearly says, after opening the body, that there is a lot of oozing of the blood from the heart, and then that filled entire cavity. So that it's a clear indication, because after all doctor is also an expert, and the one who is conducting the postmortem is also has got an experience, he has got degrees and all, he is a trained person. So when he gives such a report, postmortem report, it is but natural that we have to fix the responsibility, criminal liability, or rather the culpability on the person, intern, who is responsible, because once you perform a duty, it is your responsibility to ensure that whatever work you take up, do it with all due diligence. Take the care that is required, isn't it? And and what kind of culpability can you fix? Can you fix murder? Can you book him under the murder 302 or culpable homicide to 299 or culpable homicide not amounting to murder 299 or 300 and or grievous hurt or simple hurt or negligent or careless? So what is the culpability, criminal liability of this? Of course, he has committed some crime, and you need to know the difference between crime and an offence. Is offence defined or is crime defined? Which one is defined?
In my
Here is medical negligence, right?
Medical negligence. You are not going to, because the person died. Person also died. Can we not say culpable homicide not amounting murder? Now what you said is right, but then I want justification. I am only asking options. Why can't we or the IO can put him under the section of culpable homicide and not amounting to murder? It is murder.
Ma'am, it's culpable homicide, right? So we can't put the section not amounting to murder. Here it's the murder death.
It is murder, then we can keep murder also. See, why not murder or culpable homicide not amounting to murder?
For murder, there has to be intention. There is no
See,
intention as a-
that's what I want you to tell that word intention, isn't it? To decide who caused the death again, whether the act can be a death or negligence or rash or homicide or culpable homicide not amounting to death or culpable homicide amounting to murder and all. I mean, in order to understand all this, what is required is we have to understand mens rea in detail. Now, mens rea is a range of mental state. So, from one range to the other extreme range. Now, in one range, at the extreme left side of the range, we are putting intention. Then, less severe compared to intention, less severe mens rea can be given the status of what we call knowledge. Now, knowledge, intention, knowledge, then we say reason to believe, then comes your rashness, then comes the negligence. So, if you take the descending order, then whatever is the mind state, if you have a higher degree of knowledge, higher degree of awareness, and you also know the consequences, because every act has got an evil consequence. We have discussed that when we are discussing actus reus. We said every act results in a consequence which is evil consequence, isn't it? When it is evil consequence, then we say culpability or the criminal liability can be fixed, because that is prohibited by law and that is definitely an offence or a crime. So hence punishable under law. That's what we have understood. Now that means the evil consequences that flow out of the act is important. Now when we say intention, there is another thing behind that. Now it all starts with a motive. Now though motive is never defined in anywhere in the penal laws, yet motive is very, very important. When there is a direct thing which proves, then there is no need for us to understand the motive. But when a case is going to rest or base its verdict solely on the circumstantial evidences, which are not direct evidences, probably motive has a great role to prove. It will add. So what is motive? A driving factor, isn't it? A driving factor to make you design the intent, isn't it? Make you design the intent. Now, what is a motive to understand with an example? Let us say a thief commits theft, isn't it? A thief commits theft. That is the manifestation of a crime, isn't it? Ulterior object or whatever. Now, why is he doing that? Why is he why he opted this particular theft? Because he doesn't have money. He wants to become overnight a crorepati, a rich person. So that is the motive. That is the motive. So to become rich or to suppress his hunger, whatever is the motive. So for that he is adopting this method. Ulterior motive is this intention. He develops an intention, and then that is the ulterior object. The initial object is something that is a driving force which making him to conceive this particular idea or a desire. That is, to commit theft is the final thing, but then in order to achieve that, he has got a motive. What is that motive? Either he doesn't have the money, or he wants to become rich, or whatever may be, or let us say a beautiful brother is there, a sister is there, and the brother observes that there is a so-called boyfriend of the sister who constantly does some stalking on her, and inko tang kar rahe har roz. So once the brother comes to know about this, so he develops a kind of revenge. He wants to take revenge. He bears some grudge. He wants to take revenge. So that is the driving force. Now how is he going to achieve that? He may attack the boyfriend with an axe and then kill him, or take a pistol and then do that, or any other method he may choose. So that he develops slowly that intention, that desire, and then he also knows this is purposeful with all his will. He understands that, and then it is purposefully being done, and he also understands the consequences. He has a thorough knowledge. If I am going to shoot with a pistol, it is definitely going to end in the death of I am very sure of the death of the person. I have that knowledge also. And then I also know what is the consequence that flows out of the act. What is the act? By using a weapon, by loading it, and then pointing it towards the boyfriend and then trying to shoot him. These are all actus reus. And then this is the motive behind all these acts, or is that I bore a grudge, or as the beautiful brother, the brother wants to take revenge, isn't it? That is the driving force that we call as the motive, because this is, nobody has seen this. Let us say there are no direct witnesses or eyewitnesses for that, and only prosecution has to prove this. Now how are they going to prove? There are other conduct of the person, other circumstantial evidences that are there before them. They are going to prove that. Am I clear about this? Difference between motive and then the intention?
Yes, ma'am.
Motive is the driving force. It is the what you call the initial object, and maybe we can say the intention is the ulterior object. Intention we are keeping at a very higher pedestal, higher degree of culpability. So when we say higher degree of criminal liability or higher degree of culpability, what do you understand? Commensurate to that, punishment should also be equally higher, isn't it? When the culpability, criminal liability is at a higher degree or on a higher degree, we also have to presume that the punishment accordingly that can be given to such an act should also be equally at a higher pedestal. Don't you think so? Yes?
Yes, ma'am.
So, now at the higher pedestal we said intention. Now, then comes knowledge. So, is intention, knowledge both are equal or not? Is there any difference? Is there any difference between these two? Anybody? Wild guess? Is there any difference?
Yes, ma'am.
What is that? What is the difference?
Yeah, I think the intention is I want to achieve something, and knowledge is do I have the means to receive that?
Do I have?
Do I have the means? Knowledge is
Not means. It's not means.
oh, that's what my wording might be wrong, but what I want to say is knowledge is something so that I can achieve something.
Knowledge is, I know the consequences. Yes.
Knowledge refers that even though the person knows the consequences of his actions, he will still do it.
He will?
Still do it.
He will still do it, isn't it? Now, I may not have intention. So why intention is given a higher pedestal? Why knowledge is given a little lesser degree of mensiria? If you want to see the gradation of mensiria, we are talking about the gradation of mensiria. So at one end, I told you, at the extreme left end, we have purposeful act. That is a murder, kidnap, and all these come. And as you progress, there is in the travel, there is in the range, it is the knowledge next, a little lesser, higher degree of severity. Then comes the reason to believe. Then comes rashness. Then comes least will be the negligence. So in that order, the mensiria is going to grade. Now according to that, the punishment that has to be levied upon the person who is supposed to have committed this particular crime, we have to fix up the culpability. Accordingly, only punishment will be given. Once you fix up the mensiria and then culpability, then you can award the punishment accordingly. But you cannot be, when there, if this range or gradation is absent, then for everybody you have to give a similar kind of a punishment. So for that reason, depending on, though earlier it was not very much taken into account, but in the modern criminal law and all, lot of importance is given to the mindset or state of mind of a person at the time of committing the crime. Now we have to understand this grade. So why knowledge? What is knowledge? What is the difference? As somebody rightly said, no, I know the consequences, because evil consequences is what is very important. After there are cause and effect, isn't it? What is the evil effect? What is the consequences of this particular act? I know that, but I don't intend to do it. That desire to do a thing, and then consequences, evil consequences may happen. I may have the knowledge, but then if my intentions are not there, then that you cannot put knowledge also on par with the intention. Intention, there is purposeful, willful thing, desire strongly, and then I am very sure whatever desire or whatever ultimate thing I wanted to happen, it can happen. Probability is very, very high, isn't it? So all that is there in intention. And intention and knowledge is also inherent in intention, isn't it? Knowledge is also inherent in intention. So that is the reason why intention we are trying to keep at a very high pedestal. So when the prosecution can prove the intention, when the prosecution can prove intention, there you have the punishment more. So this is very well said and explained in if you try to examine 219 and 300, culpable homicide amounting to murder, culpable homicide not amounting to murder, 219 and 300. If you see the difference, if you understand these particular two sections, then you would have understood what is intention, what is knowledge, what is voluntarily, and then the other shades of mensiria. So accordingly, the 304, if you see, there is part 1 punishment part of it, part 2 part it. Why in one case it is death and life imprisonment, why in other case it is only 7 years imprisonment. So if you examine these sections, you will understand. You will understand that the part or the role played by the mensiria and its grading, and accordingly why punishment has to be severe in case of the prosecution can prove that this particular individual's case is coming under the mensiria grade of intention, and why a particular act is coming under the gradation of mensiria of knowledge, and then reason to believe, and then the rash and negligent act. So we have to understand one by one in a very, very clear manner. Now coming to the knowledge, we said intention, there should be some motive for that, desire or a strong feeling for that. So we conceive that, and then that gets reflected into intention, where we know the consequences, we have made thoroughly all preparations, and we want to ensure that at any cost the result should be obvious and all. So that is intention. So in that, again, knowledge, when we say awareness of the possibilities of the consequences of the act. So this is very important. That means I am aware, that knowledge is that there is a possibility. So the consequences of my action I envisage, I envisage, and I know that there is a possibility. That may be there. I mean, the degree differs. It may be less, it may be higher. But then I never desired the result. That is very important. I never desired, or I never intend to do that. But then if I do that, this may be the consequence. That much knowledge is with me. That much knowledge is with me. That means aware of the consequences are likely to be proved. Likely to be produced. I know that. It may or may not. Or it may be lesser or it may be a higher degree. That is knowledge. Am I clear about knowledge?
Yes, ma'am.
So knowledge only, it differs from the intention only in this degree. So what the person who is doing the act is, he is aware. He is aware of the possibilities of consequences of the act. That means it may result in a lesser degree or higher degree. But I don't have any desired result. I don't wish that the ultimate thing should happen. Isn't it? Consequence I do know. That is knowledge. Now when it comes to reason to believe, that is, there is a sufficient ground. If you examine all the grounds that are there, there is sufficient ground, reason or ground to believe that the consequences will be there. That is reason to believe, isn't it? Here also there is no desired result, but you don't care about the consequence. That is what is there in reason to believe. You don't care about the consequences. So what is reason to believe? You have sufficient reason, sufficient factors which will make you believe that the consequences will be there. The consequences are going to be there. But then you never intended that, you never designed the result. But you don't want to care the consequences. You don't want to care about the consequences. Is about reason to believe. Now when it comes to rashness, rashness is what? Can anybody define in your own wordings or in your own understanding? How will you understand rashness? Here, do you feel that consequences are probable or known? Yes?
Well, I would take example of rash driving. That is not rashness.
Rash driving, what do you understand? Rash driver, does he know that if he drives in a rash way, that will result in some accident? Or can we say overconfidence?
Yes, he knows about it.
Knowledge is there, no desire. No desire. Suppose he goes with let us say he is under enumerated condition. He has taken a lot of alcohol, and then he knows, if I take alcohol, my voluntary muscles will not be under my control, and that may result in some accident. Is that knowledge with him or not?
Yes.
So that knowledge is there. That means I am clear about consequences. If I am under the influence of alcohol, if I am not alert, if my voluntary muscles are not under my control, this may definitely result in some accident, is the fact which is already known to me. Because I am a driver, regular driver, I know that how fatigue of muscles will be there, and that too when I am under the influence of alcohol, all the more my muscles are not going to be in my control, is a fact that is very well known to me, because I am after all a driver doing regularly, routinely this work of driving, isn't it? So that means what? I am clear about consequences. What is going to happen if I am not going? The thing is, see, the motion of a vehicle is after all, if you understand little of dynamics and all, the physics, little physics and all, a moving vehicle, a very going with a very high speed, if somebody wants to apply brakes, it is not going to come to rest all of a sudden, isn't it? It will not come to halt all of a sudden. Because of the inertia of the vehicle, that means when somebody is in the state of motion, they will be in the state of motion. So some force is required to stop that. Here the force is the brake. So you have to physically apply the brake. If you foresee the consequence, then if you are a prudent man with a reasonable understanding and all, you should apply brake, isn't it? And you know the mechanics also that immediately if you apply brake from some distance, reasonable distance, you have to apply the brake. Otherwise, what will happen? The moment you apply the brake, it is not going to come to a halt. It takes some time and it drags to some distance before the vehicle comes to a standstill, isn't it? So if you know how these particular knowledge, that means being a driver, regularly doing the job of driving, he will definitely know about these things. And then even if he tries to apply brakes at the last minute, maybe the vehicle as anticipated is not coming to a halt to the spot where he anticipated. Maybe by that time he must have already hit a person and that has resulted in the death of the person. So why am I telling this example is that I know the consequences because I am a regular driver, I know the consequences. So what happens? But only thing is, I hope, heart of hearts, I do have sympathy, I hope that it should not have happened. Had I taken little care, due diligence, and then had I been little careful about things, I would have averted the accident. That kind of feeling also at times he may express. So, what kind of, are you going to say, just because that resulted in the death of the person, are we straight away as an agent of prosecution trying to put him behind bars under the section 300 and 299? So, should the punishment be that severe? Because he doesn't have intention. He doesn't have any intention. Had there been intention and also knowledge, then definitely we would have put him under 300 or 299. Am I clear about this? Rashness.
Yes, ma'am. Yes, ma'am.
Yes, ma'am.
So, no desire, no result. I never expect that such a mishap should happen. Nay, I may or may not cared about consequences. This is the thing. I don't want this to happen, but at the same time it has happened. I wish that it should not have happened. But had I taken some due care, due diligence, and these things, the accident would have been, it should not have happened. So this kind of a thing is called rashness. This is called rashness. So accordingly, the punishment that has to be levied should also be little less compared to the punishment that can be given where intention is proved, isn't it? That is the reason intention comes first, then comes knowledge, and then comes the rashness. Then when we study the definitions under IPC, these things, we'll get to know more about this. Actual sections, if you read and all, we'll get to know more about this with examples and all. For time being, let us only say that these are the factors, the awareness, the consequences, then whether you have whether you desire the result, end result, or whether you don't desire the end results and all. Based on this range will be there. Now, negligence, why are we putting at the last end, that is the extreme rightmost corner we are putting? What is the reason for that? What do we understand by negligence? This only says that where you should have taken precaution, but you have not taken, you failed to take any precaution, though you never intended that result, but then the concept of consequences is also not there. No consequence, no concept of consequences. Isn't it?
And does negligence mean lack of knowledge?
Yes, lack of knowledge. If there is knowledge, we should have straight away put it under knowledge only. Isn't it? Why are we keeping that as a separate head and then saying that negligence? Let us say one doctor, he performed and then he thought it is successful operation. Then the person, the next in command, as the second doctor, because always major operations, there is team of doctors, I told you already. The second doctor handed over the case to second doctor and he left, let us say. Then the duty of the second doctor is to ensure that there is proper, lot of implements and lot of instruments are kept inside, for the ease of operation and all. They all put these instruments in, and it is the second in command doctor who has to ensure that all the instruments are removed, because he is also will be by the side of the main doctor also. So it so happened that abruptly the main doctor left, thinking that the operation is very successful, and it is for the other fellow to stitch it, isn't it? Because he is busy, the main doctor is so busy, he will complete the operation and then he is leaving, because he has waited for some time, there nothing unto happened, and then he is, that operation was successful, and then he left the theatre. Then the second doctor, who is supposed to stitch everything proper and ensure that there is no implement put inside the body cavity and stitch it up nicely and all, for further anesthetist to ensure that proper anesthesia and proper dose is given and all. I mean, this is series of acts that encompass. But then the doctor realizes that he has suddenly he tried to count the implements. Now he feels that small cotton or maybe one forceps or maybe some scissors, small scissors is kept inside, and then that may create some trouble and all. Here we have to put him under negligence, medical negligence, isn't it? We cannot put him under rash also, nor under knowledge, nor under intention. We can only at the best attribute negligence. Of course, medical negligence these days are also, I mean, lot of compensation, lot of punishment for these people and all, when medical ethics and all, they come into play. So this is what we need to understand from the range of mental state, that is the menseria. It has got a gradation. It starts from intention, then goes up to knowledge, which is a little lesser, then comes reason to believe, then we have rashness, then we have the negligence. Is this clear?
Yes, ma'am.
To everybody? Yes?
Yes, so far so it's clear, but I do have a question.
Yes, please.
The opposite of knowledge is ignorance. So where
The opposite of knowledge, I mean, we should not go here. Legal terminologies are something different from the dictionary terminology, isn't it? Legal jargon is something different. You cannot equate a meaning which is there in a dictionary and then try to have an analogy for the same word in the legal terminology. This is jargon. It will not have the same connotation or same meaning. You can now ask.
yes, my question was, is there any place for ignorance over here in this hierarchy?
See, ignorance also, there is a maxim. Ignorance of fact is tolerable. It is excusable, isn't it? In law, maxim says, ignorance of law is ignorance of fact is excusable. If you don't understand, if you have no knowledge of, let us say, a particular fact, it is all right. It is excusable. But then ignorance of law is not excusable. You cannot say go to some other state and then say kill a person. No, I have no knowledge. I am unaware. I am ignorant. Please, my lord, under ignorance you can excuse me. You cannot attribute menseria to me. Can he say that? So ignorance of law is never used. You are supposed to, when you belong to that state, when you go to that state, know the law of the land. You cannot just take a plea or innocence or under shelter of ignorance. Ignorance of law is not excusable. But nevertheless, ignorance of any fact is it can be tolerated. It can be excused. Am I clear?
Oh, yeah. Except ignorance of law, other ignorance will be put into consideration.
Ignorance is again, as I said, ignorance about a particular fact. You can be ignorant, isn't it? But when it comes to law, you are supposed to know. I can't say murder definition, I don't know. Is this called murder? Am I punishable under this? I have no idea, my lord, and I am so ignorant. You please ignore me. You please don't attribute menseria. I am not aware. You can't take that kind of a plea. That's what I am saying. That their ignorance doesn't work. Every man, as a general rule, are supposed to be prudent unless otherwise proven otherwise. Every person is proved to be sane unless until he is proven insane, isn't it? Like that, the certain things are presumed by law. Law presumes that certain things are known to a prudent man, reasonable man, isn't it? So like that, you cannot plea under the guise of ignorance. Ignorance of law is never excused. Am I clear?
Yes.
So what we have to understand is, while examining the accused person's state of mind, as I said, 2-3 things are important. What are these things? You have to examine whether this accused is aware, whether he has got knowledge, whether that escalated to the level of an intention regarding whatever action he is doing, and whether that particular action of him is leading to some evil consequences, whether that effect or the ultimate object, whether that is prohibited or forbidden by the act. That is what we need to understand now. Is this concept very clear?
Yes, sir.
So should we move on to the other slide?
Ma'am, I have a question.
Please go ahead and ask.
Ma'am, can you repeat the degree of criminal culpability, the range of the increasing or decreasing order of the culpability, which is knowledge, rashness, and negligence, everything, including that?
What else you want?
Ma'am, the degree of culpability, the increasing or decreasing order of the culpability, with intention, knowledge, and
See, that's what I told you. In the range of mens rea is after all an element, mental element that we need to prove, because in order to prove a crime, we need to prove 2 very important things. See, in order to understand crime per se, there are 2 very important essential elements that we need to understand. One is actus reus, and then any act which doesn't have the mental element in it, absence of mens rea, cannot be called as a crime, isn't it? So in order to understand that, we said mens rea is also very important, and mens rea is nothing but the mental state of the person who is committing the crime, isn't it? Now how he is going to, how we can understand the mens rea? Now we said there has to be some motive. It all starts in the mind game as a motive, a strong desire I try to develop. That is, why I develop this, a strong idea I try to develop, and then that has to be manifested, isn't it? Idea has to be manifested, and I develop a desire. For example, I have given the example of a thief. Now he wants to, he commits theft. Why is he doing? He wants some money, or he wants to become rich overnight. So for that he wants money. So there is a motive, and motive is always, if it is direct, there is no issue, we can understand that. But most of the time motive is not known. It is very, very difficult to establish motive. Prosecution, it becomes very difficult if it is an indirect case or a case resting on circumstantial evidence completely. It will be very difficult for the prosecution to prove that. So for proving motive, in such cases, proving motive becomes very, very important. So we need to understand how will we understand that motive. So what is the cause, root cause for that? Why is he indulging in theft? Why is he killing somebody? Why is he kidnapping somebody? Isn't it? So somebody tried to do some previous act to him, and then he bore some grudge, and then he wants to take revenge, or he wants to settle the disputes, whatever may be the thing. So some strong desire he develops, and then that culminates into intention. Now he wants to do something, and then the consequences of which also he knows that whether this may result in the desired act or not, that also he knows, isn't it? There should be awareness of the desired act, what he ultimately wants to achieve, that also he should be very clear in his mind. That means a knowledge, complete knowledge. If I do this, there is a very sure way of getting the result. That much also awareness should be there. So then we said, then it becomes knowledge, isn't it? So intention, knowledge is already there. And a small degree of knowledge is also there in intention. Desire plus intention, isn't it? Desire and knowledge. But knowledge per se, a person if he has got, he may not have the intention of doing it. He may also, he only knows the consequences of that, isn't it? Now, the other gradation we said is the reason to believe. There are sufficient reasons to believe. The probability that the outcome may, in all probability, will result is reasonable belief. That means if I put all my reasons together and there is a higher probability of that particular thing occurring, then we say that as a reasonable belief, reason to believe. Then comes your rashness, then comes negligence and all. I mean, there is a gradation. So, when there is a gradation of menseria, degree of menseria, then accordingly the punishment has to be levied. We cannot be giving everybody same kind of a punishment irrespective of the menseria gradation, isn't it? That is the reason. So, for smaller degree of menseria, small punishment should be there. Higher degree of menseria, higher punishment should be there. So, for that reason, we try to have this gradation ranging from intention to negligence, and intention, knowledge, reason to believe. At times in the section, if you see, they are all combined in one word called voluntarily. They are using a word, common word, when the mindset or when the menseria, in the menseria, if you can see the intention, knowledge and also reason to believe. If these three things are there, then we use a single word called voluntarily. Voluntarily causing hurt, isn't it? Voluntarily trying to do that. So we use this voluntarily. Am I clear about this?
Yes, ma'am. Yes, ma'am.
Any other doubt? Should we move on to the other slide? So let me also, whatever is depicted here, we'll read it and understand. Menseria refers to, is the screen visible to everybody now? Whatever screen I have showing right now?
Yes, ma'am. It is.
It is talking about menseria, isn't it? Menseria refers to the mental state or intent of the individual at the time of criminal act, what he was committing. It involves examining the accused person's state of mind, and it includes awareness, knowledge and intention. We have named it differently, intention, knowledge, and then we say reason to believe and all. There are other things. Menseria is essential because it helps differentiate between deliberate criminal behavior and actions that might have been accidental occur. So there are two extremes, as I have told you: malicious, purposeful, intentional acts on one hand, and then acts of which there is no desire, no intended result, only consequences they are aware, and consequences may or may not, the probability may be there, probability may not be there. So that is on the extreme right hand side where we say negligence, isn't it? So we have to understand, establish, and then differentiate between the deliberate actions and then actions which are unintentional, which are accidental, which have happened as an accident. So these two extreme things need to be understood. One second, my slide is not moving, just wait for a second. Yes, is the screen visible now? So we said, I think we have already discussed this slide. Menseria categorized into, I said, intention, recklessness, negligence, strict liability. So various levels of culpability. If you want to fix up the blameworthiness, culpability is nothing but one of the grounds for putting somebody blameworthy or calling somebody blameworthy. That is called culpability. Now intention, what do we understand? The individual purposefully engages in criminal act. That means purposefully he wants to be very sure in achieving his act. That act should ultimately give him the result. That's what purposefully, the word purposefully means. Now, in reckless, what we understand, and in the intention also, one more thing is fully aware. See that, fully aware of the consequences. Not that there is a probability, likelihood, or may or may not happen. These things are not there. Fully aware of the consequences. If I do that point blank, if I put a gun, if I am aiming at a person, if my gun is already loaded, I am very sure of the death of the person. Isn't it? Unless until some miracle, something happens. Otherwise, it's, miracle happening or magic happening is, it's so chance. You cannot anticipate every time some miracle will happen. This is sure. He is fully aware of the consequence. That is intention. Now, when it comes to recklessness, the person acts with conscious disregard. See that wording. Disregard for the potential harm that may result from their actions. He is aware. See, recklessness, the person is aware. The consequences are going to happen. He knows. I have given the example of a drunken driving. In that, the person is fully drunken. But then he is so confident that several occasions, even if I am drunken, it never in my life, I have never hit any person. I have not injured any person. Not even a iota of doubt is there for me. So I don't care. When I am so much experienced, why should I care? Isn't it? I am very sure that nothing will happen. See, that kind of a thing is called recklessness. The person acts with conscious disregard for the potential harm that may result from their action. That is called recklessness. Am I clear about this? Recklessness. He knows, but then he doesn't pay attention. He disregards the potential harm. Potential harm is going to happen, but then I don't care. Disregard for the potential harm. What is negligence? The individual fails to exercise reasonable care, leading to unintended harm. He doesn't aim any harm in either of the cases. Recklessness and negligence, in either of the cases, nobody intends any, expresses any intention to kill somebody, isn't it? It is not a deliberate action, isn't it? Somebody is trying to say something? Yes, is there anything? Am I audible?
No, ma'am, you may continue.
See, recklessness is that you need to understand, because there is a disregard, conscious, willful disregard for the consequences that are going to happen. Then, negligence, the individual fails to exercise reasonable care, leading to the unintended harm. He never intended harm. His aim is to kill, not to kill people as a killing spree. He doesn't intend to do that. He doesn't want to kill people on the road. But then what is the result? Unintended. The harm which never he intended is happening. And then if he takes little care, due diligence we say, little care and caution. If he takes little care, then he would have averted the accident. Isn't it? That little care he is supposed to take and which he has not taken. That is called the negligence. Now in the statute at times we have two very important liabilities apart from criminal liability. We also, as a part of criminal liability only, but more significant when we talk of tort and other things, especially tort and all. So we have two more concepts like strict liability and absolute liability. The only difference between the two being, in absolute liability you cannot take any excuses, the will of God or the act of a third person or the contributory negligence of the victim herself, and then these things you cannot take in these kind of defenses you cannot take in case of let us say absolute liability, whereas strict liability there are some exceptions or some defenses you can take. That's the only thing. Now these are very much relevant when we talk of tort, not very strictly some criminal cases and all that may be a little relevant. Now what is strict liability? In certain cases the statute itself imposes where mens rea need not be proved as a separate element, isn't it? the act by itself attracts crime. That itself is termed as crime, isn't it? No separate initiative need to be taken by the prosecution to prove mens rea, whether it is there or not. The statute itself gives that sanction. So that is called strict liability. Now, in oleum gas and then that Sriram fertilizer and all, I mean, these are the things, and Bhopal gas kind of things, you know. This is strict liability. That means the statute, being a corporate this thing or some industry, it is paramount, because why that is made strict liable? See, public at large, it is not the individual health or individual's interest that is involved. It is public at large, their society at large, that interest is paramount when compared to individual interest. So that is the reason why the liability is so strict there. Unlike criminal liability of all the range that we have seen, strict liability is something very serious, isn't it? So you are supposed to know, you are supposed to take these precautions. You can't say I am not aware, I am ignorant, and then it is out of only some negligence it has happened, and all. You can't take that plea. So that is the reason why they said the statutory sanction itself is there. In the definition itself it is given that you need not have any mens rea. The very act of not rendering the effluent harmless and then making it harmful and then releasing it into the water body where the people are supposed to drink the water. You cannot just take the plea. Ignorance plea or some innocence plea you cannot take. So the law mandates, it is given a sanction in the law itself, statute itself gives you sanction that no separate effort need to be made by the prosecution to prove the mens rea per se. So the act itself is, it can establish the guilt of the person, is what is known as the strict liability. As our friend has already said that several cases of, of course, N.C. Mehta is one environmentalist. He is into several cases. Wherever you click N.C. Mehta, you get number of cases there, versus Union of India and all, you get several cases there. So that is about the strict liability. Of course, we have to understand between intention, transferred intention, then the knowledge. So I think I take up this one slide and will just wind it off. Now, as I said, intention means desired objective or desire to achieve certain purpose. There is a purpose I want to achieve and I am achieving through this objective of intention. Sometimes deleterious for the other human being or the society at large. So my intention may be a wrong intention. If it is not going to harm anybody or public at large, so why should I be punished, isn't it? But intention so strong, a desire, an objective which I want to achieve, but at the cost of some harm to the other human being or at the cost of harm to the entire society at large. So don't you think that such kind of an intention has to be punished in law? So even in Indian Penal Code, as I told you, in several sections you see in the definition clauses itself that these words are reflected. The bad or guilty intentions of a human being are worded properly. They are worded as intentionally, voluntarily, willfully, deliberately. These words are there. So by the very definition, we know that this has to be proved. When I say theft, murder, these are to be proved. Intention, knowledge has to be proved. It is not implied. You have to take a special pain to prove that. Intention, knowledge, and then name. So the words that indicate these things, mental state or mens rea, are different. For each crime, it is not the same. It is not the same. It differs. In one case, it may be intentionally. In one case, it is voluntarily. Having knowledge to do it, such a type of different wording is there to indicate mens rea in different categories of crimes against the human body, or maybe it is crime against the property. Now, what is transferred intention? So, with an example, let us try to understand this. I think we have already discussed this anyway. A intended to murder X. For achieving this objective, A mixes poison in X's food and places it on the X table. So, normally X will have it when I lay that on the table. He is going to have his food. So, when I mix poison in his food, it is but natural he will take it, and then that may result in the death of that person. That is what I plan. Now, however, while feeling unusually hungry, raids excess lunch and then dies, eats excess lunch and then he dies in the process. But A never intended to kill Y, isn't it? His intention is to kill X, only that. Maybe because of previous enmity, whatever may be the motive behind, he wanted to kill that. But meanwhile, this third fellow comes very innocently, and then unusually that particular fateful day he feels very hungry. So whatever food or lunch that is intended for X, and after consumption of which intended desire was that X should die. That is the intention of A. Now, when it comes to menseria or liability, then A is liable for Y's murder. Now he cannot take a plea saying that my intention was never to kill Y, I never killed him, and my intention was something different, my desire was something different. I planned entire thing for X, but you cannot, instead of X when Y is dying, you cannot just hold me liable. You cannot put that criminal liability on me. He cannot take that kind of a plea. So A is liable as if he has done the murder, directly A's murder, even though he did not intend it. Even though he did not intend, he intended only X's murder, but not Y's murder. So even if he says, even if he pleads before the court, see, by X is very much alive. My intention is only to kill X, but then it never resulted in X's death. So, my desire was not fulfilled. Now instead somebody Y dies, how am I liable for punishment? He cannot just take that plea. See, so this is called transferred intention, and it is mentioned in 301 IPC. So that is about transferred intention. And when it comes to knowledge, it is the awareness of the consequences of any act or omission. As we have already discussed in the previous classes, any act also includes in the definition omissions also. Now, this particular knowledge element, we know the consequence. We may not intend it, but then that knowledge that this thing is going to happen after my act or as a consequence of my act, this thing is probable or likely to happen, or 10% probable or 100% probable or 99% probable. So I have that awareness. I have the knowledge, that particular fact knowledge is with me. So that is called knowledge. Example is, a bus driver has knowledge that he does not keep his eyes on the road while driving, an accident may ensue even if he doesn't intend it. See, he cannot be ignorant. He cannot, all his eyes, muzzle and every motion of his body should be in his control. All his voluntary muscles have to be under his control. If something he can foresee that an accident is going to happen, he should be in a position to anticipate the distance and should be in a position to apply brake and avert the accident happening, isn't it? So the driver has knowledge, but then what is missing? He doesn't have any intention. So whatever punishment that has to be given to him, it should not be based on his intentions, because he never had any intention. But nevertheless, his act is responsible in committing that accident or in committing that event. Otherwise the event would not have happened. Had he been little careful and all, had he been little taken due care, or reasonably he must have anticipated the foreseen the accident happening. So this is knowledge. This is knowledge. Then negligence, again two types we can understand: advertent and inadvertent. Advertent and then inadvertent. Avoidable. Advertent means avoidable. See, advertent negligence is also known as negligence where the risk is foreseen. That means I know, I anticipated, foreseen, yet the risk is undertaken foolishly. Please try to understand each word. Advertent negligence is which is avoidable. The accident or whatever or the event could have been avoided. Advertent, avoided, it could be avoided. When it can be avoided? If you take due diligence, due care, careful, if you had been little careful, it would have been avoided. But then what I did, I can, you know the risk, you have anticipated the risk also, but what is that you are not doing? I want to just take the risk, though it is not warranted, I still take the risk, isn't it? So it is foolish at that particular point of time. To take risk is foolish act. So foolishly thinking that no bad consequences shall result. How can you say that? When there is a probability that that event is going to happen 50%, then to take risk in such occasions is a foolish act. You are doing that where you are not supposed to do it. You know you have foreseen the risk. You know that it can be avoided, but still you want to venture. But still you want to take a chance. That is a foolish act. You know it very well. That can be avoided. That is called advertent negligence. This is common in rash driving. We have seen that in rash driving. If an accident ensues, the driver is liable for the advertent negligence or rash or necklace. So willful negligence, that means he could have avoided if he is little careful, but he is foolish. He wants to take that risk. He wants to take it as a challenge. Take that, invite that risk. Result is that ends in some accident. So that is called willful negligence. So the expression advertent means avoidable. As I told you, it can be avoided. Had there been some kind of a little due diligence exercise by the driver, by all means it could have been avoided. But then he wants to invite trouble for himself, he wants to take risks unduly. So then it becomes unavoidable. The accident becomes unavoidable. Such unavoidable kind of incidents are called willful negligence. The person knows he can avoid. See, to avoid the accident is in his hands. He knows, he foresees everything, but then still, in spite of all that awareness, he wants to still take risks. He can avoid, he could have avoided, but for the conduct, his conduct. But then he refrains from doing that. He doesn't want to do it. He wants to still take risk. That is the thing. Yet he goes along to bear the risk in devil may care attitude. I don't care. Devil may care attitude means I don't care attitude. This is known as advertent negligence. Then inadvertent negligence means absence of duty to take care and due precautions. Absence to take duty to take care, due diligence. Doctor who leaves a scissor, I have told you this example, scissors inside the patient's wound, is liable for simple negligence because he did not have knowledge of them being inside when he sewed the wound. See, he could have taken, when you are doing such a big operation, it is but natural for you to take little care, isn't it? You cannot take risk like in rash negligence and all. Rashness, you cannot take that kind of a risk. But at least due care you could have taken to ensure that when I stitch, there is no way again if something is inside also, I will not be in a position. So before I stitch, let me just take care, let me just see every part of the body inside. Let me be 100% sure that I have not left any instrument inside. Let me be exercise little more care and all. So if the doctor who is attending the patient at that particular stage, if he would have thought that way, he would have averted, he would have not invited any trouble for himself. But he did not have knowledge. Knowledge means he doesn't know. When he is not anticipating, how can he anticipate even the consequences? Isn't it? He is very sure. He is very sure that he has done it perfectly. But only thing is, by some carelessness thing, he has left it, or the doctor on whom he relied upon to do this kind of a business, that in every implement you please take care to remove it, he believed in him in good faith and all. So he tried to believe him, and then he, having faith in him, thought that he must have done his job perfectly. So he, with that intention, he has stitched it, but only to find at a later point, X-ray वगैरह लिख रहा तो इसमें scissors दिख रहा. So neither he has intention nor knowledge, but then it has happened. This is merely an inadvertent, which is not avoidable thing. So absence of due care is the only thing that we can attribute to such act. So I think with this we have done with This actus reus and then mens rea. I hope these two essential elements,
Causation.
everybody concepts of crime or essentials of crime, whatever you call it, you all have understood that. I mean, with that belief, we can start some other chapter fresh on Monday. So till such time, we'll call it a day and we leave the meeting in absence of any further doubts.
Thank you, ma'am. Thank you very much.
Thank you, ma'am.
Right. Okay.
Thank you, ma'am.
Monday same timing, not the same timing. Monday 6 to 7. 6 to 7 in the evening.